Good morning. I'm Kip Randall, and I'm joined by Jennifer Cavner today, and we're here to talk to you about Civil Investigative Demands, or CIDs. Before we get started, I'd like to cover a few housekeeping items. At the top of your attendance console, there are multiple application buttons for you to use during the program today. If you have any questions during the webcast, you can submit them in the question box down there at the bottom of your screen. And we'll try to answer those questions at the end of the webcast. But if a fuller answer is needed, or if we run out of time, we'll follow up with you after the webcast by email. Also, in the program materials folder, you can find a PDF of the presentation. And as you saw on the slides beforehand, if you were here a couple minutes early, this is approved for legal education hours. So for the folks that are attending live today, you have to report your hours by clicking on the continuing education sign-in button at the bottom of your screen. Then a certificate of attendance with the course numbers will be emailed to you tomorrow, along with the recording of the webcast. And finally, during the at the end of the program, if you would go ahead and fill out a survey so we can use that feedback to plan our future events. But that is all of the housekeeping matters. So we will go ahead and get started with the presentation. So by way of introduction, both Jennifer and I are part of the Husch Blackwell White Collar Government Investigations and Compliance Practice Group. And we're also both members of the firm's False Claims Act Working Group. So that's kind of our background in terms of where we're coming from. We also have significant experience in our practices with responding to CIDs. And a bit about my background, other than that, is I've been practicing for about 8 years with a focus in the government investigation space. And before that, with the law being sort of my second career, I was in the Army for about 10 years. So Jennifer, if you could go ahead and share a bit about your background, I'd appreciate it.
Yeah, absolutely. Thanks, Kip. So as Kip shared, we're both in the White Collar Government Investigation Group. I have been a litigator for over 20 years and have moved towards this practice area in the last 5 or 10 years. It is an area that I find incredibly exciting and interesting and constantly evolving. So the majority of my practice is white collar cases and also the related internal and governmental investigations and counseling that go along with that. So I have a broad breadth of experience defending clients before many federal agencies conducting investigations against our clients, including the Department of Justice, obviously, the SEC, the Commodities Future Trading Commission, the CMS, the Center for Medicare and Medicaid Services, the EPA, the NIH, and the Customs and Border Protection. So a lot of different agency investigations.
This is the agenda that we're going to follow today, but basically we want you to get an understanding of what civil investigative demands are, how they work, and then really give you an understanding so that if you receive one, you'll know kind of the next steps to take. So this is kind of how we're going to do that today. Now, this is completely in my head, what I think of when I think of a government investigation. So it's kind of like my continuum, right? So I like to think about this practice area as having like 3 pieces, which is the government investigation, the related litigation, and then compliance. Now, I've got compliance on here twice because you really want to have compliance, an effective compliance program in place before you have a government investigation. But you definitely want to have one following a government investigation. So that's why I put it here twice. So we want to make sure that we have that effective compliance program. So now what we're talking about today falls squarely within the government investigation piece of this continuum. We'll talk about this more in the next slide, but a CID is an investigative tool for the government agency to use as part of its investigation into whatever civil violation that's looking at. And so this is squarely where this falls into. So really to talk about what is a civil investigative demand, to kind of level set there, like it's kind of often referred to as an administrative subpoena. And like I said before, it's just an investigative tool for a lot of different government agencies to investigate those civil violations. Now, it's similar to a criminal grand jury subpoena in the fact that it's part of the investigative stage. And then it's also kind of like a civil discovery tool in the fact that it has some of the same types of information that are being requested as say like a request for production of documents or the request for information through interrogatories and those types of things. And so that's where you're going to see some of those similarities. But if you could kind of walk us through, Jennifer, some of the differences between a CID and some of those other tools I was just mentioning.
Yeah, of course, absolutely. So CIDs are incredibly powerful, and as such, we've seen the government utilizing them more and more because they can use them to conduct a lot of investigation pre-litigation without a lot of constraints on the breadth of those investigations. So they're used by the Department of Justice and the Antitrust Division, the Federal Trade Commission, the Consumer Financial Protection Bureau, but mostly I see them in my practice in fraud investigations pursuant to the False Claims Act. So CIDs are one of the government's main avenues to investigate and recover losses for alleged fraud on the government pursuant to the FCA. The FCA can impose both civil and criminal liability, so it is very serious if there's an investigation going on pursuant to that. And the government or private plaintiffs that are called qui tam relators or whistleblowers can file suit, and the government can investigate these claims on their own initiative or after the relator files its qui tam action. So CIDs differ from a civil subpoena because they're issued before a complaint is filed. In that way, they're similar to a grand jury subpoena, but they're civil in nature. So often the DOJ will issue the CID to conduct discovery, before the party knows what allegations are against it. So when a client receives a CID, it is a bit of a heart-stopping moment because they know that there's something in what they are doing that is under investigation. It may not mean they're the target of the investigation, but certainly the government is investigating them, usually in my cases for potential fraud. So whereas subpoenas can be issued in both civil and criminal contexts by courts and governmental agencies to compel testimony or production of documents, subpoenas are generally broader and can be used in a wider array of legal proceedings. So the key differences between CIDs and subpoenas are the issuing authority. CIDs are typically from the government, while subpoenas can be issued from courts or agencies or even individuals. And the scope of CIDs are used specifically for civil investigations pre-litigation, whereas subpoenas can be used in both civil and criminal cases. The legal framework is also different for CIDs and subpoenas, and the statutes and regulations and rules governing them are different.
So talking about the statutes that kind of authorize the issuance of CIDs, here's a list of, a lot of those, and to go through a few of those. I mean, so Jennifer mentioned the False Claims Act, and this is really where we see a lot of the CIDs, but this authorizes the DOJ to issue a CID when investigating those potential false claims against the government. Then you have the Federal Trade Commission can issue CIDs for investigations related to unfair or deceptive business practices. Then you've got the Consumer Financial Protection Bureau has the authority to issue CIDs related to their investigations. The antitrust, this is another one that you can see a bit in the analog state laws as with the antitrust, and this one allows the DOJ to then issue CIDs for their antitrust investigations. And with those comparable state laws, you can see with the False Claims Act, and antitrust, those types of investigations at the state level. Then on the other side there, we've got HIPAA related to healthcare fraud. The RICO is an interesting one because, kind of like the False Claims Act, it can have both civil and criminal implications. So can the RICO. There can be both civil and criminal implications there. Then you have FIREA, and then both the CFTC and SEC can issue CIDs for investigations into commodities and securities. So it's kind of a laundry list there, but it's just to show the sort of the number of agencies that can issue these CIDs. And like Jennifer said, I've dealt with a few in the False Claims Act space and sort of in the antitrust space at the federal and the state level, and then also some with the Federal Trade Commission. But what about you, Jennifer? Where have you sort of seen CIDs?
Yeah, so similar to your practice, I'd say about half of my practice are healthcare related clients, so CIDs in conjunction with DOJ and CMS, mostly regarding the submission of bills for reimbursement by a federal program. That is probably half of the practice. And then the other half is sort of everything else. So we have represented clients regarding investigations and CIDs with the EPA, regarding environmental exposure issues, or with the NIH regarding federal grant funding issues, and also with Customs and Border Patrol regarding duties and importation issues. Also in antitrust matters and commodities issues and SEC insider trading things as well. So it's very, very broad. They're utilized by a lot of different agencies because they are so effective for the government to gain a lot of information regarding an investigation pretty quickly.
So moving now to sort of authority and scope of a CID. So we talked a little bit about this in previous slides, but an agency can issue this. So it just requires the approval by the senior official within that agency, whether it's the Department of Justice or Federal Trade Commission. So Jennifer, what keeps these agencies in check when it comes to issuing CIDs, and so what are the limitations on their authority, so they're just not sort of out there just issuing CIDs on fishing expeditions, so to speak?
Yeah. So, I mean, a lot of our clients are used to or have been exposed to some amount of litigation. And when there's litigation discovery, it's very different because you can challenge the scope of the discovery, and you can always go to the court to get some assistance in defining scope. CIDs are less so. That's what makes them so powerful, but there are limitations. I mean, an agency does not have the authority to issue a CID unreasonably. So while it's unusual in my practice, a recipient may file a legal document with the court or the agency to challenge the CID and the statutory authority that it was issued under. You may also push back by not responding to a CID. I would not recommend that, but I know that entities have done that, and the government can respond by moving to enforce the CID. Again, would not be my advice. So there are bases to challenge a CID. You can challenge the statutory authority. So if the agency exceeds its bounds to issue the CID, you can certainly challenge that. If the information requested in the CID is not relevant to the investigation, it's not described specifically, you can also challenge it on that grounds. Also, if they don't have jurisdiction over the subject matter or the entities from whom the information is sought, you can challenge it on that basis as well. The CID cannot violate due process rights, so there is due process safety nets there, and they also cannot access confidential or privileged information such as attorney-client or work product information or trade secrets. There's also time issues related to responding to a CID, so an agency must give you the time to respond to it. So if they don't do those things, then you can challenge. But all of that said, it's very unlikely that, I have not seen an agency exceed its authority or do those kinds of things. They certainly do issue very broad CIDs. That is very, very typical. But we do not typically move to modify or push back on the CID and not answer. First, because the chances of success are very low. The judicial review is incredibly narrow, and any relief usually favors the government. A court might sometimes modify the CID in the recipient's favor, but it is rare. So, but equally important is that if you fight back against the CID, the government may suspect that you're trying to avoid responding to it for other reasons rather than the breadth of the CID. And that may pique their investigation and their focus on you even more. What I have found is that the best chance of negotiating the scope of a CID is to work with the governmental agency directly. So that's typically what I advise doing and what we do. So the government's authority to obtain materials is broad because the government issues CIDs before suit, particularly under the FCA. So when courts are looking at the scope of a CID, they have a lot of discretion rather than what you're used to in traditional discovery battles and civil litigation. So the court's review is extremely limited under the standard, and it must enforce the CID if the investigation is for a legitimate purpose and is not abusing the judicial process, and if the Department of Justice, in terms of the FCA, has identified the type of conduct at issue and describes the material with particularity. So that is to say that despite the ability to access the courts to challenge the scope of a CID, the likelihood of success is low. An agency really has a lot of discretion to issue that CID broadly. And the approach I typically suggest is having me reach out on behalf of the client with the assistant U.S. attorney or investigating agent and try to help them understand that limiting the scope would actually assist them in their investigation because it would focus the information that's provided to them.
So after the relevant agency goes ahead and drafts the CID and gets it approved, it's going to be served on the recipient. That can either come by certified mail or personal delivery, and usually. So now this document is in the hands of the CEO or the general counsel or some other executive. And Jennifer, what should they expect to see with that? What are the main components of a CID? What does that look like, and what kind of information is usually requested by the CID?
Yeah, so often clients have never been served with this kind of document before. So when you get it, it will say, whatever the issuing agency is, U.S. Department of Justice or whoever the issuing agent and parties are. So it's a very official looking document. And within the first couple of pages, it will provide a detailed description of the information requested or the documents sought. Usually it provides a lot of definitions and gives you some idea into the scope of the investigation and what they are investigating. They also have to provide the legal basis for the CID, such as under the False Claims Act, presenting a false claim for payment or approval. And they also have to provide instructions for compliance. So you'll see the deadlines and often very extensive formatting details regarding how they want the information produced. So it looks a lot like civil discovery because they'll tell you the scope and they'll tell you the definitions and they'll tell you the individuals at issue and they'll tell you exactly what they're looking for. And often there's requests for documents as well as interrogatories. And then the government likes things electronically. So they have very specific ways that they want the data uploaded with certain metadata information provided as well, and usually an index of those documents. So they can also ask for testimony from individuals as well as interrogatories and requests for production. So that is typically what you see, and it's a bundle of documents that you'll get. So one thing to keep in mind, and one thing that I'm always thinking about when we're responding to CIDs or talking to the government, is that the government, all the criminal, civil, and agency attorneys regularly communicate with each other. about their investigations, and they routinely refer matters to each other. So this includes sharing information learned during the CID and investigation process. So prosecutors who issue a CID can also share that information with any other DOJ officer or employee or another agency. So it's important to just keep that in mind. I mean, that's obviously not a basis to withhold anything, but it gives you an eye towards providing context for any potential problematic documents that you're providing. And it's also important to, as you're developing a relationship with your assistant U.S. attorneys, trying to understand, okay, I'm receiving a CID. They will often share some information about, is there a parallel criminal investigation going on? Because that can also be happening. So again, developing a rapport and relationship with the agency issuing the CID is incredibly, incredibly important. CID materials are typically not subject to disclosure under the Freedom of Information Act. But again, the DOJ can use the evidence obtained from a CID in any court case or grand jury information. And information obtained from a CID can be utilized in other proceedings in which the DOJ is involved or other investigations. So again, it's important just to keep an eye on the information you're providing, knowing where your problematic documents are, and trying to educate the government as you go along to try to give them context for anything that you find problematic and developing your defenses along the way.
So now we're at the point where a CID has been issued, and so we're kind of going to go through how to respond to that. But first, we want to talk about some initial steps to take once you receive that CID. And first of all, that's important to just do an initial review of the CID so that you can understand sort of the scope and the requirements, what's expected, and also very importantly, the deadline to comply with the CID. Also, we'd recommend to, like, at that point, to engage legal counsel that has experience, that has, worked with these government agencies before, responded to CIDs before, because it can be a complex process, even though it may seem sort of simple in terms of, handing over X number of documents, but you want to have that legal counsel there to sort of advise you on the production of those documents and sort of the legal risks that are associated with that. And then also the legal counsel can help you with the preservation of the documents and information, that all of that information needs to be held at that point. You don't want things to be inadvertently destroyed through, document retention policies and things like that. So it's very important to make sure that you understand that the initial scope of the CID and that you're preserving any information or documents that could be responsive to that. So those are sort of the, those initial steps. And it's important to move promptly when you're receiving a CID, because like I said, there are deadlines for compliance. Once legal counsel gets involved, as Jennifer was saying, having a discussion with the assistant U.S. attorney or the attorney for the agency, and a lot of times an extension to comply with that, with the CID can be requested. But again, you just want to make sure that you're moving promptly through all of this to show that your compliance with the CID. And then also, as I said, on the preservation side, you want to make sure that you take care of that quickly, so that nothing is inadvertently destroyed. So Jennifer, if you could discuss the importance of working with legal counsel during the response process a little bit more fully than I did there, I'd appreciate it.
Yeah, absolutely. And I know a lot of clients do choose to retain legal counsel to assist them in responding to a CID. Of course, I would advise for that because it is an incredibly complicated process. And if you have not had experience with it before, it can be a bit overwhelming. And going back, in addition to what Kip said, I would also say, if you receive a CID, you should inform your board of directors and put your carriers on notice for any applicable insurance policies that might apply to the scope of the CID and the response. There might be directors and officers liability insurance or general liability insurance or some other sort of specialized insurance that might help cover the costs for the CID response, which can be incredibly helpful. So back to the point for legal counsel, we highly suggest that in responding to a DOJ or any other CID, because they can provide the expertise and they ensure compliance and protect the organization's interests. Hiring outside counsel can also benefit the organization by reducing the strain on the organization's legal department. Clients need to run their business day to day. A CID can be an incredibly distracting event that requires a lot of attention. So having your whole legal department pivot to address that can really press on a company's resources. So it helps to have outside counsel handle that piece of it, of course, in conjunction with internal legal, but it can help with that burden. So it can reduce the strain on the legal department's day-to-day operations, and it also can minimize any conflict that might exist between in-house counsel and any kind of senior management. Those folks, particularly senior management, may be implicated in the investigation. And so it's incredibly helpful to have an objective third party, your legal counsel, step in to assist in that investigation instead of having company folks questioning or probing into areas with people that they work with every day. That can be very difficult. And also legal counsel from the outside can provide a buffer between the government and the organization, which can insulate the organization as well and reduce some of that strain. So outside counsel can take the lead on the negotiations with the DOJ and then communicating that back with the client. That can be incredibly helpful. So legal counsel on the outside can also reduce the risk, that a client might be accused of interfering with the investigation. Again, having that objective third party conduct the investigation is incredibly helpful. And often it can bring insights that internal legal counsel don't always see because they're so close to the company. And obviously, legal counsel that specializes in these kinds of matters can provide an expertise for the organization that the legal department may lack. So they can also assist in conducting an internal investigation of the matter. So I think that's incredibly helpful. Often when you're being investigated for compliance issues, it really helps to stop and conduct an internal investigation of what is going on so you can assess the full scope of what the investigation may be targeting. So when you are looking for outside counsel, an organization should look for counsel, obviously, with experience in governmental entities conducting investigations such as these, and also with knowledge of your individual companies. I think that experience in FCA litigation or government investigations is critical. And I also think it helps to engage a firm that has e-discovery background. Excuse me. As Kip mentioned before, he and I are both affectionately e-discovery nerds. So we really like data and all that goes with it. And I know that, 10, 20 years ago, it may be that people could run businesses without involving electronic data, maybe 20 years ago, not 10 years ago. But in today's day and age, you would be hard pressed to find any kind of case, litigation, claim, anything, investigation that does not touch on electronic discovery, because we all email and we all have databases and we do things like that. So an investigation is going to touch on how a corporation keeps their data and communicates their information, and do they use Teams and all of those things. So having a firm that not only has the investigative background, but also has a deep breadth of knowledge on e-discovery issues can be incredibly helpful, because they can understand how everything is set up with your servers and your databases, and how you keep your emails and for how long and those kinds of things. So that can all be critical in responding to an investigation, and how far that investigation needs to go. For example, with employee cell phones or things like that. I mean, the scope can be very broad, and the government's scope of how they draft the CID can be any and all documents and information. So the way that's read, it could really include broad expanses of things and data that you might not think of at the top of your head. So I think it's critical to have outside counsel with those kinds of expertise.
What a perfect segue into the next slide. So we could probably spend the rest of our hour here on this slide alone, but we don't want anyone to fall asleep, so we'll move through it. But so, yeah, we both do the e-discovery part of these things, and so when you get to this point of responding to the CID, the gathering and producing the information, I mean, this is it. It's more complex than it may just seem at first blush, right? So as Jennifer was saying, there is so much electronic data out there that you might not think of initially. And so it's important, when you're doing this, some of the best practices here for, gathering and producing the information here is like, you want to first start off with a good detailed plan of how you're going to approach this, and rather than just kind of wading into it and start just grabbing up documents and information. And you want to have that plan ahead of time. And this is something that we frequently do. We sit down, we do interviews with IT, with some of the custodians to find out where that information is going to be housed. And that going into then that communication piece is making sure that we're communicating with the people that have that relevant data to make sure that we're collecting it and producing it. And you want to make sure that throughout all of this process that you're keeping good records of everything you're doing, and to ensure that you can go back and show what you did. And with that, throughout this process, I mean, we're going to say this probably a dozen more times about talking with the governmental agency that issued the CID. Throughout this process, this is we're having conversations in order to sort of try and limit the amount of data that we have to collect and review and produce, because it can become very time consuming and very expensive, that we'll go back to the government agency and say, here are the list of individuals, the custodians that we think have relevant data. We want to get basically your stamp of approval on this to move forward with these custodians. And same with search terms. When looking for that data, we'll go back to the government agency, and that's a way for us to maybe limit some of the overbroad requests by saying, okay, what specifically are you looking for here? Let's talk about the search terms that we can use to really get at what you're looking for, and then sort of dig into that piece, rather than, hey, we want all communications from this period to this period between these two people. Well, that's tens of thousands of documents and pieces of information. We don't want to look through that. We don't want to pay to look through that, and you don't want to look through that. So it's all of this is part of sort of that communication with the government, and having a good detailed plan, keeping the good records of what you're doing, and then communicating with the governmental agency so that they're later down the line, there's no surprises about why did you use this search term, or why did we use this custodian, and get into some sort of litigation with the government about that, where if there's that open line of communication and discussion throughout this process, it usually goes much more smoothly. So those are kind of what I would say are some of the the key takeaways or best practices for, when you're gathering and producing that information. So did you have any additional things to add there, Jennifer?
I mean, I agree with you 100%. I think, as Kip jokingly said, but it's true. We could talk about e-discovery all day long because it's a vast topic and critical in responding to a CID, honestly. And so we all utilize multiple layers of review and kind of quality control with regard to those issues, and a lot of checklists and trackers and things like that to make sure that we are aware of the data the client has and that we're searching it appropriately. So again, it's helpful if you engage outside counsel to find folks that do have a deep bench regarding governmental matters and also e-discovery. Those two things dovetail side by side. And since we also have that in-house, it's incredibly helpful. And I think it also makes it more cost effective. But having lawyers who understand electronic data and how things are saved can help you figure out how to preserve that data when you issue a legal hold after you've gotten a CID. And then we also have tremendous experience in accessing the data that's attainable and then processing it and reviewing it. And we also, have to get an understanding of how your servers are kept and how your databases are utilized and those kinds of things as well. So I, very early on, talked to the client about the area of business that's being investigated, how it runs, who the critical people are, to try to determine who the custodians might be that we might gather emails from. And then I also assist in drafting legal holds to send to all the relevant parties so that we don't have any issues with alleged spoliation down the line. And legal holds address a lot more than just sending an email to your workers and saying, stop, getting rid of anything regarding X. You have to understand and work with IT to figure out, how are emails kept? How are your chats kept? Like, there's just a variety of things that you're not always thinking of right off the bat that you have to suspend those during the term of the investigation. So we work closely with IT, we work closely with the client to figure out those issues and try to first preserve the data so that there are no claims of spoliation possible, and then to collect and process the data. So we try to start with what is relatively easily attainable, and but at the same time trying to understand what is not as easily attainable. And so there may be a good argument to the government to say, we have this archival data or those kinds of things, so that hopefully we don't have to go and gather that. So understanding, the area of the investigation, how the business is run, and then how the materials and information are stored and kept regarding the area of information regarding the investigation is critical. And then once you know that, then you can reach out and talk to the governmental agency regarding the scope of the CID.
So I'll move through this a little bit quickly because, as Jennifer has already said, actually moving to modify or challenge a CID is not something that is done often or very successfully, and so that's why we'll kind of move through it. But I will mention a few of the things. And Jennifer hit on this in some earlier slides about sort of the different grounds there are for modifying or challenging. But really, we're looking sort of at whether the requests are overbroad. We're talking about outside, a 20-year period, or large time frames of something, and then information that is not really relevant to the investigation. So it's kind of the over breadth there is really about a long periods of time, like outside of when any sort of events that could be coming to question are involved, or information that's not really relevant to that investigation falls into that category. And then you've got sort of the undue burden on the person who's responding is, look, this is millions and millions of documents, and the amount of time it's going to take us to do all of this it's an undue burden on the person who's responding to actually to undertake that. And then really again, sort of discuss it a bit with over breadth, but the relevance, whether the information is relevant to the investigation, or it falls well outside of anything that would be even related to the investigation. Those are just a couple of the areas, that you could, if looking at these requests, that could potentially challenge that request, or the CID, or request to have it modified in some way. But again, that's sort of the second step. The first step is the negotiating with the governmental agency, and I'll leave it to you, Jennifer, to kind of to go through that a little bit and talk more about those discussions with the government.
Yeah, of course. So yeah, as Kip said, in my practice, I found it unusual to, formally challenge a CID in that way. That said, if you did have a particularly unreasonable CID and you had a prosecutor who was not willing to work with you at all, yes, we would be ready to, challenge that. But in my practice, I've not found that to be the case. You might have a CID that's drafted outrageously, but typically the prosecutors, the assistant U.S. attorneys, and U.S. attorneys, they're humans. We work with a lot of former U.S. attorneys, AUSAs here, and prosecutors in Husch Blackwell in the white collar practice. They're people too. So I found that the normal scope is to try to approach them and, in a reasonable way, get an understanding of what they're really looking for. We often do see CIDs that, say you manufacture widgets and it says, give me every document regarding widgets for the last 10 years. Well, that's crazy, because that's every single thing you do all day long for the last 10 years. And so approaching the prosecutor early and saying, I read the CID, I see what you're asking for. There's some allegation of fraud or some investigation of fraud. Do you really want every document regarding a widget for the last 10 years? Because it will be 2 million documents. And then they have to look through that. I mean, they're humans too, and they have agents on their side reviewing all this stuff. So I've often found that they will say, oh my gosh, no, I don't want that. Yes, I'm interested in widgets, but I'm interested in widgets with this particular part, or this part sourced from this country. And then you're like, okay, well, that's different. That's a totally different scope, way more narrow. And so I found working with the government in that way is so helpful to the client and to the government. So it's really a win-win approach. So going back, after a company receives a CID, yes, you put your carriers on notice, you talk to the business, you start your legal holds, engage counsel. After we've assessed the CID, I think it's wise to reach out to the prosecutor as soon as possible, within a few days at the latest of receiving the CID. I like to get out early. It shows the government that the client takes it seriously. They are diligently, working to respond. I always, in my introductions to the prosecutor, kind of give a background to the company generally, and the diligence with which the company wants to respond. So the prosecutor gains understanding for and respect that the client really does want to comply and does want to, coordinate their response with the government. So I try to build a relationship with the prosecutors, try to establish credibility with them. And I do that by not misleading them with regard to productions or what we're going to do. I try to negotiate a scope in that first call, and then some, usually time extensions, because CIDs have very quick times to respond. Often they'll want you to produce all the documents regarding the widget within a few weeks, which is absolutely impossible. More realistically, we've had investigations go on months and months and months, and, well over a year. So it takes some time to respond to these, but I like to talk to the prosecutors early on and try to figure out what is a manageable timeframe to start producing documents, get some extensions in place, and then have them agree to what we refer to as a rolling production. So I like to produce documents as they're prepared and produced along the way. And then I typically, personally, prefer to answer interrogatories at the end once the document production is done. Sometimes the prosecutors will go for that, sometimes they won't. But I feel like for us, that's helpful because then you understand the universe of what you've produced and the evidence around the investigation, and that helps obviously formulate what the interrogatory responses would be. So at that first discussion, I also try to address with the prosecutor any particular requests that are vague, anything the client wanted clarification on, and then I try to get some documents produced as quickly as possible. Every time I talk to the prosecutor, I document that conversation in writing, and I send an email back saying, pursuant to our discussion, here's what's going on. That's very, very important because those emails can provide the basis for the limitations of the scope of your response. So it is critical to memorialize those agreements in writing. Kip and I work a lot, as you said, in e-discovery, and so we utilize some creative ways to respond to CIDs. Some are also novel to the government as well. So I've used a lot of AI and technology-assisted reviews or computer-assisted learning reviews in which we train software regarding vast quantities of documents in order to expedite the document review process. That's something that the DOJ isn't always used to, but if you can help them understand that it will be beneficial and more cost-efficient to the client and quicker to get them the information they need, I have found each time that they have agreed to it. So again, I memorialize those agreements in writing. Same thing with utilizing term searching if you need to do that to cull the scope of the documents you're looking at. So along with, developing that relationship early on with the prosecutor, I also try to keep them informed. So usually at the beginning of a case, I will do weekly updates to the prosecutor. Typically I do them on a Friday afternoon and tell them, this is what's going on, here's our production, here's our next steps. If it's an incredibly lengthy investigation, those may taper off, but I do like to do periodic check-ins, and I'm incredibly responsive to any sort of outreach from the government and always respond same day, because again, you want to create the relationship that shows that you are diligently working to respond. It creates a much more cooperative environment, and I find that it assists in the resolution of the CID as well.
And kind of to piggyback on that just a little bit, Jennifer, before we move on, I just like to say that building that relationship is important too, going just from one matter to the next as well, because there will be times when you're dealing with the same assistant U.S. attorney that you've dealt with before, and so even though this is a new recipient of a CID, you have that rapport that you've built with the prosecutor, the governmental attorney, and just that you continue to build on that throughout. So it's very important to sort of continue that relationship, and it works well because when you're dealing with the same prosecutor, assistant U.S. attorney several times, they know when you go to them, they can trust you to be straight with them and to kind of continue to move things along, and they've built that relationship. So I just wanted to add that on. So
I agree with you, Kip. And just in addition to that, I think I forgot to say, having that relationship with the prosecutor and those kinds of discussions and them knowing you are diligently trying to comply, I feel like it makes them more amenable to also share information with you with regard to whether the client is a target of the investigation, which is incredibly important to try to find out early on, and if there's any kind of parallel criminal investigation. So again, building that rapport and that good relationship and them knowing that they can rely on you for what you are stating you will do goes very far.
So I feel like everything that we've talked about so far is a strategic or legal consideration. To have a separate slide is kind of, funny, but there are a couple of additional things that I wanted to add in here. And Jennifer has talked about already about conducting an internal investigation, but this is really can be sort of a big piece of responding to a CID, and internal investigations really give the company an idea of what's going on, because a lot of times the government's asking for these documents, and if it's related to a whistleblower, there might be, they might not have all the information. And so really an internal investigation helps the company sort of develop the facts, other than just, producing X number of documents and providing information to the government. It helps the company then also really develop the facts, and in a privileged way. So this is all done by, outside counsel. It's all privileged communications, and then receive, sort of recommendations, advice on what outside counsel is seeing based on this review of the documents, interviews with key individuals. And so can really be an important tool for the company to use sort of at the same time as responding to the CID there, because, we'll talk about this in a minute in terms of with the resolution of or the CID, or sort of how the next steps after that. Like, some of those steps could involve the company being able to provide a presentation to the government agency about, what their side of the facts, and those sorts of things. And so having an internal investigation done and being able to develop those facts and being prepared to come forward and say, okay, here's what actually happened. There might be some information in here that doesn't look good, but we have explanations for that because we've done that in internal investigation. We've looked at it. So that's that's one sort of strategic consideration going through. I mean, and we've hit it over and over again, but another strategic consideration is, that communication with the governmental agency, and that's really an important piece of all of this, is staying communicating with them throughout this whole process. But I mean, really, kind of the overarching strategic consideration here is we want to sort of minimize the amount of disruption to the business as we're responding to this CID, as we're, doing an internal investigation. And, it's so, outside counsel can provide that, taking that on, so the company continues to do what it needs to do with its business operations. And then the outside counsel kind of takes this other piece and really takes the laboring oar on that, so that the company can continue to focus on what it's doing, and then the outside counsel can provide advice. So those are some of the strategic considerations. If you want to go through some of the key legal considerations, Jennifer.
Sure. Yeah. And just piggybacking on what Kip said, I mean, it is not lost on me when a client, either a company or an individual, receives a CID. I mean, that is a big moment. And so, gosh, I take that so seriously. And I feel like, for me, assisting clients through that process is incredibly rewarding, because I feel like, as much as we can, we try to understand, what that feels like, being under that kind of scrutiny, and trying to help navigate that process and keep them as educated as they can on the process and what's going to happen down the road, and what the possibilities might be, to try to take away some of, as Kip said, that burden and handling that, and also just that doubt with regard to what might happen. I mean, it's very, very stressful. On our end, regarding risk limiting, we're obviously very focused on protecting the client's interests. I mean, with regard to privilege, or with regard to something that might be incriminating. With regard to privilege, we have a lot of checks in place before document production goes out, or before information is provided to the government. Kip and I, as e-discovery lawyers, work a lot in the e-discovery space. And so we have a lot of QCs that we've developed within our firm to try to really minimize the chances of any kind of privileged material getting produced to the government. And our software is such that we're able to, locate those things if they haven't been detected during a review, and then log them so that we can put them on a privilege log for the government. So, I mean, I haven't been involved in a clawback personally, but it happens all the time. I mean, this is vast amounts of data, so something can be missed and get produced, but we're also ready to claw something back quickly from the government and get protections for that document as soon as we can.
So talking a little bit about clawing back documents, this is a horror story in a case called Omni Healthcare against MD Spine Solutions. Now, it was a False Claims Act case where a relator or whistleblower brought the case on behalf of the government, and during the government's investigation, the defendant produced some privileged documents to the government, and I don't know all the details from the facts of the case, but there were at least 16 documents initially that were produced to the government, and it seems like, based on what the court was sort of indicating, that the council didn't have some of those, privilege checks in place to make sure that those weren't going to the government. And essentially, those 16 documents went. There's a lot of other procedural things that went on with the case, but later on in the case, those documents ended up going from the government to the relator, the whistleblower, and come to find out, when counsel actually took a look at that, they ended up putting over 600 documents on a privilege log. It was 2 years later, and the court said, nope, you waived privilege. Instead of, you clawed back those 16 originally, but you didn't do a good privilege review. You didn't take the actions within a reasonable amount of time. So the court actually ended up saying that defense counsel or defendant waived the privilege, and all of those privileged documents had to be produced to the whistleblower because they've been produced to the government already in the previous production. So it's just another one of those things to be thinking of. And, one of the benefits outside counsel with those good privilege reviews can provide. So anything to add on that, Jennifer? I think we have just a couple minutes left, so I want to, so I'll let you hear. So we'll talk here a little bit about this, sort of our last slide before we get to the key takeaways, which we may not get a chance to get to here. But just, every sort of investigation is different. So, there's never a guarantee on how it's going to turn out. But we want to talk to you a little bit about some ways that, after you've responded to a CID, sort of what are some next steps. And so if you could kind of talk through some of that, Jennifer, I'd appreciate it.
Sure. So obviously the goal is for the agency to close the investigation and do nothing further. That's what we love to happen. That doesn't always happen. It does happen, but doesn't always happen. Other times we attempt to negotiate a settlement pre-litigation, or other times litigation evolves and then we have to answer that way as well. So there's a few different courses of action that can happen. It's a long process, typically, the kinds of investigations that we're involved in. Some can be shorter. I have had several kind of healthcare reviews that were very focused on specific patients or things like that. So those resolved very quickly. But a lot of the ones that Kip and I get pulled into are quite massive. And so they can go on for a while. So I try to prepare the clients in terms of stamina, that it's, not a sprint, it is a marathon. It sucks to have your business disrupted in this way with this thing kind of looming for that long, but it's going to take some time. It's the government. They don't move super fast usually. And so, again, we try to be helpful to the AUSA and the staff, and we try to keep the goal of avoiding litigation and minimizing penalties and damages if the action is ever brought. I try to provide a lot of context to the government as the documents are being produced. I remain keenly aware of any problematic documents that there might be in a document production. So I want to understand from the client the context of those documents so I can educate the government as well, and also let the government know if there's any kind of mitigating factors or compliance that the client's already put in place to address those kinds of red flags that might come up. I've found that clients, individuals and companies, they just want this over with. They want to put it behind them. But as much as the instinct might be to just produce and be done, although we try to move as quickly as possible, you have to be cautious. We don't want to drag things out, but we need to be aware of what we're doing and have our defense strategy outlined from the beginning so we can try to help persuade the DOJ to not file suit or intervene. And if there's arguments to be developed in support of any kind of motion to dismiss, if litigation should ensue, we want to develop those as well. So at the same time that I'm keeping an eye towards documents that may be unhelpful, I'm also highlighting documents that are helpful to the client along with the problematic ones, so that if there is any kind of settlement conference, I use those in the presentation of the government to try to highlight, just give context to what's going on and sort of provide balance or defense of what the government might be focused on.
So to wrap up here, to talk about a few key takeaways. So first is, as I said, want to act promptly to make sure that we're preserving data, to make sure that we're complying with any deadlines in the CID. So it's really important to act promptly once you've received a CID. And, part of one of those things that I would say is prompt action is involving legal counsel. Get outside legal counsel involved early so that they can assist with all of these initial steps and these initial actions and really take the ball and run with it from there. And so those would be my two key takeaways. And so what about you, Jennifer?
Same. You just want to be prepared to respond. I think the worst thing you can do is sit on it and pretend it's not there, because the clock is ticking. So the sooner you get it into the hands of, educated counsel and get things moving, the better off you're going to be. And start that communication with the government as promptly as possible is always going to help you out.
So I see that we have one question. Jennifer answered this a little bit already, excuse me, but since we are over the hour already, we'll follow up directly with you, Logan, and to respond to this question. So in closing, I would just like to say, thank you for joining us today. We hope that everything that we've sort of provided you today is helpful to you and your company. And just kind of, as we're signing off here, just want to remind you that it is approved for legal education. So make sure to report your hours on the continuing education sign-in button, and then you'll receive a certificate along with a recording of the webcast. And, feel free to share that recording, follow back up with us with any questions, anything that you have after, hearing it today. And then if you also would just please fill out the survey and let us know your thoughts so we can use that for future webinars. But this concludes our webinar. Thank you.